Conference recording started.
Bye-bye. Yeah.
And you're done. If that's what it is.
We have a lot of background noise, so I'm going to go ahead and activate the hand-raising feature now. So if you would, please hit 5-star.
Conference muted.
All right. If anyone else wishes to be heard, hit 5-star. And please make sure to go to my webpage and note your appearance. So, good morning. It is Friday, June 5th, 2026. We're here for various matters in case number 26-90103, Sachs Global Enterprises, and we're also here on the Sachs Digital Confirmation hearing as well. So why don't we get appearances of counsel, and then we can talk about how we're going to proceed.
Good morning, Your Honor. Are you able to hear me okay?
I can.
Great. Deborah Sinclair, Wolfie-Farr & Gallagher for the Global Debtors. With me in the room are my partners Robin Siebel, Chris DePompio, and John Brennan. And joining me virtually is my partner Allison Smith. Also with me in the room here are the Global Debtors investment banker Jamie Dares, our Chief Restructuring Officer Mark Weinstein, and joining us virtually are our Independent Director Paul Aronson, and Leticia Sanchez, who's the Managing Director at Stretto. And I'm mentioning all of them because they have signed various declarations and attestations in support of the plan.
All right. Thank you.
Good morning, Your Honor. Jared Martin, Bradley Aaron, Bolt Cummings, counsel for the SO5 Digital Debtors. Also on the line with me is my co-counsel, Michael Reardon. Our Chief Restructuring Officer, Andrew Heed, is also on the line, and Gary Begeman, our Independent Manager.
All right. Let me just go through the boxes, and that might be quicker. Mr. Lehane.
Good morning, Your Honor. Robert Lehane, Kelly Dry Warren, on behalf of Brixmore Property Group, WPF Tower B Company, WPF Tower D Company, GGP Services, Regency Centers LP, and Aventura Fashion Island LP. Thank you.
All right. Ms. Bordy.
Amine Bordy on behalf of Exonic.
Okay. Mr. Schiffer.
Good morning, Your Honor. Joseph Schiffer of Prior Cashman LLP on behalf of David Yerman Enterprises LLC, Yerman Retail North America LLC, Gurhan New York Incorporated, Caring Americas Incorporated, LVMH Moet Hennessy Louis Vuitton Inc., Richemont North America Inc., and Interlaced Holdings LLC.
All right, Mr. Prostock.
Good morning, Your Honor. Jeff Prostock on Vartabedium, Kat Hester Haynes on behalf of Salesforce. With me is my co-counsel Tom Gay with the Bilson Bergen and Schwab firm.
All right, good morning. Mr. Gallardi.
Good morning, Your Honor. Greg Gallardi of McDermott, Williams Schulte on behalf of Mr. Metric.
All right, Mr. Zur.
Good morning, Your Honor. Roy Zur on behalf of SF Wilshire BH LLC.
All right, Mr. Mano.
I'm sure that Mr. Mano heard you. This is Lorenzo Maranuzzi from Morrison and Forster on behalf of the committee, joined by my partners Doug Mantle, Raf Ferioli, and Brian Collier. Good morning.
Good morning. All right, Ms. Vesper.
Good morning, Your Honor. Margaret Vesper of Ballards Bar on behalf of Bridgewater Commons Mall 2 LLC, California Union Square LP, Centennial Waterfall Willow Bend LLC, Danbury Mall LLC, Fashion Outlets 2 LLC, Federal Realty OP LP, Scottsdale Fashion Square Limited Partnership, Street Retail LLC, Somerset Collection Limited Partnership, and the Irvine Company LLC.
Can you repeat that? No, I'm sorry. Ms. Raviel, please.
Thank you, Your Honor. Good morning. Jennifer Ravelli of Kelly Dry and Warren. I will not repeat the list. I'm here on behalf of the same parties as Mr. Lee listed in his opening. Thank you.
Did he get it correct?
I think he did.
All right, Mr. Hopkins.
Good morning, Your Honor. Chris Hopkins of Paul Weiss on behalf of the ad hoc group of DIP lenders and secured bondholders. I'm here today with my colleagues Andrew Rosenberg, Bob Britton, and Martin Salvucci.
Mr. Reardon. All right. I'll skip over you. I know you're with Mr. Martin. All right, Mr. Wynn.
Good morning, Your Honor. Hal Wynn for the United States Trustee.
All right. Mr. Cottier.
Mr. Cotlier is my partner.
Okay,
Good
thank
Chris.
you. All right. Ms. Norfleet.
Good morning, Your Honor. Kelly Norfleet from Haynes & Boone on behalf of the Global Debtors, and I'm joined in the conference room by my colleague, David Troush.
Okay. Mr. Goff. Mr. Goff, did I unmute you? No, you're still muted. You have to hit 5-star one time. All right.
Your Honor, if it's Mr. Gay,
okay.
He's co-counsel with you.
Okay, thank you. All right. Mr. Holzapfel.
Good morning, Your Honor. Caleb Holzapfel on behalf of Safety National Casualty Corporation.
All right. Mr. Feinstone.
Good morning, Your Honor. Ben Feinstone on behalf of HB Strategies.
All right. Mr. Castleman.
Good morning, Your Honor. Dan Perillo and David Castleman from Otterberg on behalf of Bank of America as ABL agent.
All right. Mr. Fleischer.
It's affiliated with Urban Edge Your Honor, can you hear me okay?
Yes.
Great. Again, good morning. Scott Fleischer on behalf of landlords affiliated with Urban Edge Properties and Westfield LLC.
All right. Mr. Fiorillo.
Good morning, Your Honor. Dan Fiorillo along with Dave Castleman from Otterberg, counsel for Bank of America, the admin agent for the DIP ABL lenders.
All right. Mr. Harris. All right. All right, Ms. Strickland. Ms. Strickland, hit 5-star one time.
Your Honor, can you hear me?
I can.
Thank you. Good morning. Rachel Strickland, Ropes and Gray on behalf of Richard Baker and Ian Putnam.
All right. Mr. Scheinberg.
Good morning, Your Honor. Good morning, Your Honor. Sid Scheinberg on behalf of Margot McKinney Jewelry and Shy Creations.
All right. Does anyone else wish to make an appearance? All right. We have a lot of people on the line, so if you're not speaking, please mute your lines. And all right, Ms. Sinclair.
Yes, Your Honor. Good morning again. Deborah Sinclair, Wilkie Farr and Gallagher for the record. With Your Honor's permission, I'd like to take the agenda slightly out of order today. I propose we start with the global debtors combined plaintiff BS hearing Then we can turn to the offset debtors combined hearing, and then following that, we could take up the interchange and Brookfield matters later in the hearing, if that's amenable to Your Honor.
All right. And there was another matter for HBB, a status conference?
Yes, apologies, Your Honor. That's what I'm referring to by the interchange conference. It's HBC on the agenda.
Okay. All right.
Yeah.
Your Honor.
Yes.
This is obviously just case administration. I don't think the agenda should be revised. It's a quick status conference concerning our motion. I propose we get it out of the way rather than ask the parties to whom that is critically important to sit through two extended, potentially protracted confirmation hearings. I don't even know to what extent these confirmation hearings are disputed, Your Honor, so forgive me. But what's the reason for moving the agenda?
Your Honor, if I can be heard, I think the main show today is confirmation. I'm happy to announce, at least on our end, that it's nearly fully consensual, so I don't anticipate this will be a long and drawn-out hearing. But I'll leave it to Your Honor to decide which order we proceed.
I mean, if we're just going to have a quick status conference, that's the only reason I asked. We can kind of get that out of the way quickly, and then we can move on to the other matters.
Yes, Your Honor. For the status conference, I'll turn the podium to my colleague, Mr. DePompio.
Okay.
Good morning, Your Honor. Christopher DePompio, Bookkeep Bar and Gallagher on behalf of the Global Debtors. I actually think Mr. Feinstone and probably Mr. Kotlier from Morrison & Forster will handle the status conference during the Nelson Agreement between themselves. We'll be here for questions that you may have, but otherwise I'll leave it to them.
All right.
Okay. Thank you, Your Honor, and thank you, Mr. DePompeo. Your Honor, this will be less than 5 minutes, I think. This status conference concerns our motion, which is filed at ECF numbers 1983 and 1984, Your Honor. The motion was actually filed pursuant to an order that Your Honor entered earlier in the case, resolving the debtor's 9019 motion concerning its settlement with certain credit card service provider defendants. Certain cash was put into proceeds. The debtors believed, and I respect the debtors for taking this position, that all of the proceeds should go to my client as our property interests. The creditors committee objected, and so we have a contested matter that we still have to sort through. We filed our motion, Your Honor, pursuant to Your Honor's order. The creditors committee is the only party that objected. We have negotiated, although we couldn't disagree more on the substance, we have been able to negotiate a procedure to get this resolved. And what we'd like to ask Your Honor is if Your Honor has the ability to schedule us a hearing on July 15th or as soon thereafter as the court is able to do it. That's really the main purpose that we'd like to accomplish today, just getting on Your Honor's calendar, and then we'd step out of the way and let the main event proceed.
All right, Mr. Kotlier. Did you hit 5 star? Okay, there you go.
Good morning, Your Honor. Can you hear me okay?
I can.
Thank you. For the record, Brian Kotlier of Morrison & Forster on behalf of the committee. Your Honor, this is a status conference, so I promise I will be very brief. We agree we're here on the schedule, and we're asking for a hearing date in July. Thank you.
All right, thank you. I think July 15th, so the afternoon of July 15th would work, 1 o'clock?
That's great, Your Honor. Thank you.
All right.
Yes, thank you.
We in the committee, we also have an agreement, Your Honor, on certain discovery-focused dates leading up to that hearing.
Okay.
But if it's okay with Your Honor, we'll document that and submit something to the court afterwards. We've got an agreement in principle. We won't belabor the record with that today. But thank you for scheduling that, and we appreciate it very much.
All right, thank you. All right, Ms. Sinclair? Thank you, Mr. Pompeo.
Thank you, Your Honor.
All right.
For the record, Deborah Sinclair, Wilkie Bar.
All right.
Okay. Proceeding with the combined hearing, Your Honor. We're here today for the combined hearing on the disclosure statement and confirmation of the plan for Saks Global Enterprises, LLC, and its affiliated global debtors. As I mentioned a couple of minutes ago, we are very proud to be here today with a plan that is nearly fully consensual, not a small feat in a case of this size and complexity. complexity. And so I'd first like to thank everybody that was involved in getting us to this critical moment. The various stakeholders, all of their counsel and advisors, the U.S. trustee, and of course the nonstop efforts of the management team and the thousands of employees who kept the company operating through this process. We'd also like to thank you, obviously, Judge Perez, and your staff for accommodating our many scheduling requests in this case and helping us to manage a very complex process efficiently. Thank you for that. With that, if it pleases the court, what I propose for our combined hearing is that we first start with a brief overview of the Chapter 11 cases and the restructuring. And after anyone else would like to give an opening, I'm happy to present the argument and evidence in favor of both final approval of the DS and confirmation of the plan. Your Honor, the plan is the product of months of hard-fought negotiations and really tireless efforts to emerge as a stronger and more focused Saks Global. At its heart, the plan gives a new financial foundation to three of the most storied names in American luxury retail: Neiman Marcus, Saks Fifth Avenue, and Bergdorf Goodman. These iconic brands are here before you today, ready to emerge with a fortified balance sheet, a right-sized store footprint, renewed brand and partner relationships, and a refined focus on their core luxury retail business. I want to take a few moments to highlight the company's accomplishments in Chapter 11 because I think they're very important for the record. Throughout the bankruptcy process, Saks Global has achieved significant milestones, and together they've positioned us to emerge as a stronger and better capitalized company. In January, we secured immediate access to $400 million of a $1 billion new money DIP facility, as well as $240 in incremental availability under our ABL. That was followed by an additional $300 million under the new money DIP in February. And as Your Honor knows, in March, we obtained approval of our 5-year business plan from the ad hoc group, which unlocks that last $300 million draw under the DIP. In April, we entered into our restructuring support agreement with more than 90% of the ad hoc group agreeing to support the Chapter 11 plan. Through the RSA, we also secured an additional $500 million in exit financing from those lenders. In May, we reached a global settlement with the ad hoc group and the official committee of unsecured creditors. That settlement resolved all of the UCC's issues in these Chapter 11 cases. In connection with that settlement, the UCC agreed to mail a letter recommending that all unsecured creditors vote in favor of the plan and stating that the plan embodies the most favorable settlement attainable for the company's unsecured creditors. Your Honor then approved our disclosure statement on a conditional basis on May 1, and we began soliciting votes on the plan, bringing us to today's confirmation hearing. And we're now pleased to present a plan that is really overwhelmingly supported by our creditor base, including more than 93% of the OpCo general unsecured creditors and 100% of the go-forward OpCo and HoldCo trade creditors. In addition to these Chapter 11 achievements, the company has meaningfully improved its financial and operational performance. We've exceeded the projections set forth in the DIP budget throughout the cases. Our sales and inventory results have consistently outperformed our internal plans. The company is driving increases in retail sales and revenue month to month. And we've also reached deals with many critical service providers whose support and cooperation during this process has enabled the company to smoothly maintain its supply chain network, marketing channels, and other operations and technology functions. I'd also like to take a moment here to recognize the company's relationship with its brands. As this court knows, in a retail bankruptcy, brand confidence is everything, and our brand partners have demonstrated that confidence since day one of these cases. The company has dedicated significant time in bankruptcy to strengthening those relationships, and those efforts have been a clear success. Since the petition date, the company has seen a significant acceleration of inventory flow. We generated $2.6 billion in retail receipts since the filing, which exceeds our plan. We reached agreements with 500 brands across all categories on go-forward trade terms. All of the company's top 200 brands have continued doing business with us. To date, we have paid or committed to pay over $600 million in pre-petition claims to hundreds of partners, including large fashion houses, but also smaller brands. And notably, those small and independent designers and fashion brands represent 46% of the total brands who have been offered recovery on pre-petition claims. And of course, we've made our post-petition payments on time and in the ordinary course of business. Your Honor, the brand community has demonstrated time and again in these cases that it is committed to the future of Saks Global. The brands are truly at the heart of this business, and we are proud that we have been able to revitalize so many of those relationships during Chapter 11. One last operational piece I'd like to focus on here is that the company has utilized this process to refocus on its core luxury retail business, specifically full-price stores. During the Chapter 11 process, we sharpened our focus on luxury and full-line selling by streamlining the majority of our off-price business. We realigned our supply chain network, we right-sized our corporate team to align with our go-forward strategy, and we advanced the integration of the Saks Global and Neiman Marcus Group businesses. Additionally, and very importantly, the company optimized the Neiman Marcus and Saks Fifth Avenue store footprint. As I think Your Honor knows, this is a very significant effort and the result of many strategic steps, including first, we developed a new store footprint to ensure a profitable fleet going forward. The majority of the stores in our emergence plan are outperforming the company's internal plans. Second, we monetized unexpired leases for certain of our closing stores, which generated significant value for the estate. And third, we successfully negotiated settlements with our largest landlords, including Simon Property Group and Brookfield Properties, which locked in restructured lease terms that align with our go-forward business plan. The result is that Saks Global will maintain a portfolio of high-performing stores in desirable locations with a strong concentration of luxury customers. Our footprint at emergence consists of 49 total full-line luxury stores, 33 Neiman Marcus stores, 15 Saks Fifth Avenue locations, including the flagship here in Manhattan, and Bergdorf Goodman. The company will also maintain 12 physical Saks Off Fifth locations, which will serve primarily as a channel for residual inventory. So what's next for Saks Global? Today, the court's confirmation of the plan will enable Saks Global to emerge well-positioned to compete as a premier American multi-brand luxury retailer. The plan will deleverage Saks' pre-petition balance sheet by approximately 75%. At emergence, the plan ensures that the company will have the necessary liquidity not only to fund its operations, but to invest in future growth. We expect liquidity to increase over time as we drive that continued momentum and positive cash flow. The plan targets $9 billion in gross merchandise value and approximately $7.2 billion in net revenue by fiscal year 2030, with double-digit adjusted EBITDA. And that's all from this focused, full-price selling strategy and a smaller, healthier store fleet. All told, the plan positions the company to drive sustained, profitable growth. The company will have the opportunity to thrive in the years to come, building on its loyal customer base and its dedicated sales associates to reimagine the multi-brand luxury retail experience. Your Honor, Saks Global's bankruptcy is a Chapter 11 success story, a historic business that has used this process to strengthen its operational foundation, to revitalize its long-standing relationships, and to right-size its balance sheet. The reorganized company will continue to play a key role in the American luxury retail industry, employing more than 15,000 people, buying billions of dollars in inventory at cost annually, and serving loyal customers who continue to show their support for the brand. This is why the plan has generated the overwhelming support of the company's creditor base and its economic stakeholders, including the ad hoc group, the committee, and its constituents. This incredible result was possible because of the commitment of the company's experienced, highly reputable management team and a talented and dedicated employee base that will now lead the business into its next chapter of growth. With that, Your Honor, unless anyone else would like to make an opening statement, I will turn to the evidence in support of the DS and confirmation of the plan.
All right. Who else would like to make an opening statement?
Your Honor, I'd love to, if Your Honor could indulge me for a minute.
Absolutely.
Lorenzo Marinuzzi from Morrison and Forster, again, for the record, on behalf of the official committee of unsecured creditors, joined by my partners and also the law firm of Cole Schatz as local co-counsel. The punchline here, Your Honor, is that the UCC is supportive of plan confirmation. Documents are coming around by email, and I'm sure my colleagues are reviewing. If there's any issues, we'll know, but otherwise we assume everything is as we expect it to be, and so we're supportive of plan confirmation. I'd just like to spend a minute or two talking about how the UCC sees this case and talk generally about how we got here. Your Honor didn't hear much from us during the case. That's not because the UCC wasn't active. It's really because the UCC and all the major constituents here, the debtors and the ad hoc lender group in particular, acted smartly to move the case forward as quickly and smoothly as possible, and that took a lot of work. The UCC itself is comprised of 11 members that include and represent pension, labor, financial creditors, landlords, merchandising partners, and vendors. Some of the members are household names. All of these members were represented individually by very seasoned and sophisticated lawyers on the committee. This committee hired our firms, Alex Partners and Houlihan Lokey, to represent it. It was a very active committee. Each member has invested a great deal of personal time keeping current on case activities and participating in regular and frequent committee meetings. They have a long history with the company as well, and we're thankful that the members have been as engaged as they have been here and so willing to help the UCC professionals get smarter than we otherwise could have been. From the time we got up and running in early February, a few themes emerged in this case. First, Saks was going to be successful only with the support from the major brands and trading partners. Otherwise, it was just an ordinary retailer. Second, time was nobody's friend. This case needed to move quickly. And third, there were a number of events leading up to the bankruptcy filing that warranted a thorough investigation. The UCC immediately tackled the DIP financing, which was already contested at the first day hearing before the committee was even put in place. And the DIP, I think, proved to be the first moment of trust for the parties. There was an inherent tension in being asked to continue to provide merchandise and trade support while not having certainty of payment. And mindful of what happened in Toys R Us years ago, and because many of the members of the UCC themselves had been strung along by prior management with promises of payments that never came, the UCC negotiated important protections for creditors under the DIP order. In particular, under the DIP order, the new money DIP loans and the DIP roll-up loans were subordinated to post-petition obligations of concession and consignment vendors arising from post-petition sales. Second, concession and consignment vendors were deemed to have valid and perfected rights for goods in the global debtor's possession as of the petition date, regardless of whether such rights were properly perfected. 3, stub rent was paid to landlords. And 4, the DIP lenders were required to marshal away from unencumbered assets, including avoidance actions, and the value of Holdco 2's assets. While this was happening, at the same time, the company was asking for final approval of its critical vendor order, and the UCC insisted that nearly half of the $700 million of proposed critical vendor dollars be used within 14 days of entry of the final DIP order, and that's, in fact, what happened. And we don't see this in every case, really. This laid the foundation for where we are today and really reflected the commitments from the company, its creditors, and the ad hoc lender group to get to the end of this case together and come out as a healthier enterprise, which we're on the verge of doing. While this was happening, the UCC conducted an investigation of the company's prior transactions, including the Neiman Marcus acquisition, the LME transaction, and the conduct of officers and directors at the time of those transactions. The UCC also investigated and identified unusual transactions with respect to brand licensing rights, forgiveness of insider loans, payments of bonuses, borrowing base irregularities, and other matters. And the UCC coordinated with counsel for the debtor special committee to ensure that these potential... Sorry, can you hear me?
Yeah, I can hear you now.
Sorry. And this is ultimately what occurred in this case through the UCC settlement with the company and the ad hoc group. That settlement creates a litigation trust funded with $20 million. The parties painstakingly, and I emphasize pain in that word, identified the claims that were being preserved and the parties were not getting a release under the plan so that the trust could determine whether to bring those claims and how best to dispose of them. The UCC and lenders agreed to a sharing mechanism for proceeds, reflecting the fact that the DIP loan is impaired. The settlement provides for a small cash distribution to go forward trade on the OpCo and digital debtor sides. It provides for the broad waiver of ordinary course avoidance actions for trade creditors, vendors, and landlords. And importantly, it provides for the continuation of the PBGC-sponsored plans and the CBA and the payment of indentured trustee fees. The most important thing here, though, Your Honor, is that the settlement allows the company to emerge as a healthy company coming out of bankruptcy without being mired in bankruptcy a day longer than necessary, and that's really important. I spent a couple of minutes patting the UCC's collective back, but we don't get here without all of the collective hard work of the debtors professionals and the professionals for the ad hoc group of lenders. There were many late-night conversations among our teams. It's always a pleasure to work on a case with outstanding professionals all around, and we're blessed to have that here. With that, I'd like to thank the court chambers for accommodating us throughout this case on behalf of the UCC and its professionals. And unless the court has any questions, I will stop talking. Thank you.
All right, thank you. All right, anyone else wish to make an opening statement? All right, it's back to you, Ms. Sinclair.
Thank you, Your Honor. I'll first start with the evidentiary matters, which I think we can take through quickly. We filed our witness and exhibit list. I believe it's docket number 2627, but there may have been a revision to that this morning. Either way, the references I'll use to the exhibits and the docket numbers are all still accurate. So first, I'll move the declaration of Leticia Sanchez of Stretto, which is exhibit number 22, filed at docket number 2604 under seal, with a redacted version filed at docket number 2605. That's the declaration of Stretto that sets forth the voting results and also the details of the various opt-ins and opt-outs received by Stretto.
All right, just hold on just a second. Let me just. Okay. The one that was filed this morning is 2658. So, does anyone object to the admission of Ms. Sanchez's declaration filed at 2658-21 and 22 as her direct testimony in connection with the confirmation hearing subject to cross-examination? All right, hearing no objection, that will be admitted subject to cross-examination at the appropriate time if necessary. All right, that's admitted.
Thank you, Your Honor. Next would be the declaration of Mark Weinstein, the Global Debtors Chief Restructuring Officer. I believe it's exhibit number 23, filed at docket number 2611.
All right. Does anyone object to the admission of Mr. Weinstein's declaration filed at 2658-23 as his direct testimony in connection with confirmation? All right, hearing no objection, that will be admitted as his direct testimony subject to cross-examination at the appropriate time.
Yes, Your Honor. Next, the declaration of Jamie Baird of PJT Partners, who's the debtor's investment banker. That's exhibit number 24, which was originally filed at docket number 2606.
All right, does anyone object to the admission of the declaration of Jamie Baird as his direct testimony in connection with confirmation subject to cross-examination at the appropriate time? All right, hearing no objections, exhibit 2658-24 will be admitted as Mr. Baird's direct testimony subject to cross-examination.
Thank you. Next, the declaration of Paul Aronson in support of the plan. That's exhibit number 25, filed at docket number 2602.
All right, does anyone object to the admission of the declaration of Mr. Paul Aronson at 2658-25 as his direct testimony in connection with confirmation subject to cross-examination? All right, that exhibit will be admitted as his direct testimony subject to cross-examination if necessary.
Yes, Your Honor. Finally, we'd like to move the various certificates of service solicitation materials, as well as the affidavit of the New York Times regarding publication notice of the DS order. Those are exhibits 15 through 20 on the list.
All right. Any objection to the admission of 2658-15 through 2658-20 of those exhibits? All right, hearing no objection, 2658-15 through and including 2658-15 to 2658-20 will be admitted.
Thank you, Your Honor. With that, I can turn to the presentation, and I'll take first the disclosure statement. We conducted solicitation of the plan beginning on May 4th, 2026, in accordance with the solicitation procedures that Your Honor approved at the hearing we held on May 1. The disclosure statement contains information in each of the categories that courts typically look for when they're making the determination as to whether a disclosure statement contains adequate information for the purposes of Section 1125 of the Bankruptcy Code. Here, those pieces of information include the events that led to the filing, the material terms of the Chapter 11 plan, as well as the financial information, the valuation, the projections that would be relevant to creditors' decisions whether to vote to accept or reject the plan. The debtor submits that the disclosure statement contains adequate information within the meaning of Section 1125, and none of the parties who have filed objections or reservation of rights today are doing so with respect to the disclosure statement or its adequacy. So unless Your Honor has any questions for me or others wish to be heard, we request that the court now approve the DS on a final basis.
All right. Anyone else wish to be heard with respect to the final approval of the disclosure statement?
Your Honor, Howland to the U.S. trustee.
Yes, go ahead.
Howland to the U.S.
Yes.
Your Honor, we did file an objection to the plan and disclosure statement. We did work out almost all of the issues that we could work out. In terms of the disclosure statement and the solicitation, we do have an objection to the opt-out. Your Honor have heard it before. We continue to raise those issues. As Your Honor know, we're in the Fifth Circuit in the Container Store in one of your cases arguing that. But for the purposes of today, I'm just laying out the U.S. trustee's general opposition to the use of the opt-out. I understand Your Honor have ruled it in the past, so I won't belabor the arguments, and I will just rest on the pleading. But in terms of all of the other points we had on the objection, counsel, for the debtor, we spoke and we incorporated language that resolves all of those issues that we could resolve, except the opt-out. Thank you, Your Honor.
Thank you. Thank you, Mr. Wynn. All right. Anyone else wish to be heard on the disclosure statement? All right. I've had an opportunity to review it as well as review the evidence, particularly Mr. Weinstein's declaration. And I think that the disclosure statement provides sufficient and adequate information for a reasonable hypothetical investor to look at in order to make a decision. So I'm going to approve that on a final basis.
Thank you, Your Honor. With that, I think we can turn to confirmation of the plan. We filed an amended plan overnight on Wednesday into Thursday at docket number 2601. We then filed a further amended plan overnight last night at docket number 2651. As evidenced by those filings, we have made a number of modifications to the plan since the solicitation version was mailed out, but none of those were material. And I won't go through them line by line, but instead I think it's helpful to the court if I explain just the categories that those changes fall into, and there's really a handful of that. One is documentation of the UCC settlement and the litigation trust construct. Second is resolving informal comments from landlords, many of whose counsel are on the phone today and have appeared. Third is properly accounting for the settlement we reached with Ms. Bordy and her client, Axonic. Fourth is accounting for the disclaimer of certain equity interests. And fifth, resolving informal comments from both the ABL lenders and Citi as the pre-petition agent on the notes. We also filed a confirmation order on May 29th. That was at docket number 2387. And overnight, prior to the hearing, we filed a revised order at docket number 23. Sorry, I don't have it in front of me. I wrote 2387 twice, Your Honor. My team will help me get
I'll tell you.
the number if you need it.
No, I know the number. Hold on a second. It is 2655.
Thank you for the assist, Your Honor. So docket number 2655, the purpose of nearly all the changes in that document is to reflect resolutions to both formal and informal objections that we've been receiving. Again, just so that you can understand the categories in that red line. The objections and the comments came in from a number of the debtors' insurers, their surety bond providers, landlords and other contract counterparties, at least one bank, and some government agencies. The changes to the confirmation order also reflect valuable settlements, not only with the Unsecured Creditors Committee, as you know, but also with Exonic, with the Tax Office Digital Debtors, and with an ad hoc group of lenders in the top host structure who we've been in contact with. All told, in addition to reaching consensus on our plan and confirmation order with all of those parties, we received 12 formal objections to the plan and at least 15 informal reach-outs or reservations of rights. We're proud to let the court know that we have now reached resolutions with all of those parties except for the U.S. trustee with respect to the opt-out and the former directors and officers. We've received 10 formal cure objections and several informal reach-outs regarding cures as well. Our plan does give us the flexibility to deal with cure disputes up to the plan effective date, and we are already working with all of those parties to try to resolve their disputes around the cure amounts. If for some reason we cannot reach a resolution, we will bring it back to Your Honor at a later date. But for purposes of today's hearing, we continue to work with those parties and expect to deal with them all consensually by the plan effective date. I do think it's important to note again here the overwhelming creditor support of the plan. The figures I presented earlier, 93% of the OPCO creditors, 100% of the go-forward trade, that really illustrates the general consensus of the debtors' unsecured creditor body around this plan. With respect to Section 1129, if Your Honor has questions about how our plan meets each of the statutory requirements for confirmation, I'm happy to answer those or walk through them. But in the interest of time, I am mindful that there are many people on the phone, so I'm not planning to walk through each factor and would just rely on the arguments set forth in our brief.
Yeah, I don't have any particular questions.
If Your Honor is amenable, then I would turn to the U.S. trustee's objection, and I'd just like to make a few points here, as I know Mr. Wynn is resting on his pleadings, and that Your Honor is very familiar with the case law on these points. But just to lay it out for the record, I think the facts of this case very much support upholding the third-party release construct. The third-party releases are critical to this plan, the part and parcel of the global settlement that we struck with the ad hoc group and with the Unsecured Creditors Committee, and they're integral to the success of this restructuring. As you know, the UCC supports the plan, and within that, the third-party release. The parties that are bound by the opt-out mechanic that the U.S. trustee opposes are all either in the voting classes, which again are overwhelmingly supporting the plan, or they are in classes that are unimpaired and are going to recover 100%. In our ballots and our opt-out forms, we made it very easy for creditors to understand exactly what it is that they would have to do to vote in favor of or to reject the plan, or otherwise to opt out on their ballot or by returning an opt-out form, either by mail or electronically. We know those forms were mailed to the creditors by Stretto. That's all documented in our affidavits of service. We know that it was easy to opt out because we saw hundreds of creditors that actually did send back opt-out. And consistent with precedent in this district, we did use an opt-in mechanic for creditors who are not receiving a distribution under the plan. The U.S. trustee's objection wrongfully relies on the Supreme Court's precedent in the Purdue Pharma bankruptcy. In Harrington, the court clearly preserved consensual releases, which is the type of release we're dealing with here for the reasons I just described. The U.S. trustee's argument that state law should govern the consent construct is also incorrect. It was roundly rejected by the district court in the Container Store bankruptcy. That court was unequivocal that federal law gives bankruptcy courts the authority to approve consensual third-party releases. In particular, Section 1123b6 gives the court authority to approve consensual third-party releases if they're not inconsistent with the bankruptcy code. And Section 105, of course, gives the court broad equitable powers. The U.S. trustee's objections were recently rejected by the district court in the Container Store case, and the global debtors opt-in and opt-out mechanics are substantially similar, if not substantially identical, to several plans that were recently confirmed in this district, including the Lightner Company, which was confirmed this past May, and OBI and Cumulus Media, which were confirmed this past April. The U.S. trustee's objection does not articulate any reason that the result here should be different, Your Honor, and so for those reasons, we would ask that you overrule the U.S. trustee's objection.
All right. Anyone else wish to be heard with respect to confirmation?
Good morning, Your Honor. Joseph Schiffer, Prior Cashman LLP, on behalf of a long list of vendors, perhaps not as long a list as Mr. Lahane's. but if you'd like me to repeat them, I can. Your Honor, my clients consist of some of the debtor's most important and iconic high-fashion luxury vendors. These vendors have numerous executory contracts with the vendors, consisting primarily of concession and consignment agreements. We filed a reservation of rights at docket number 2509 with respect to the plan, which provides for the assumption of all executory contracts, if not specifically identified for rejection, as well as a limited objection to certain of the plan supplement documents that listed some of our contracts with a unspecified cure amount. Your Honor, putting aside the fact that no cure amount was identified for these contracts, our basic concern has been that it would be very difficult, just given the flow of commerce, to identify the precise cure amount as of a given date until that date passes. And I know, Your Honor, there are numerous business issues that are being worked out, particularly as it relates to concession agreements among the business people that don't require the court's attention. Your Honor, to be clear, my clients strongly support confirmation of the plan. We have worked very constructively with the debtors throughout this case. We recognize the importance of facts to the luxury retail market, and the reorganization contemplated by the plan has our full support and confidence. Continuing the theme of working constructively, since we filed the reservation of rights, we reached out to counsel to the debtors, and we agreed that the reservation of rights and limited objection to the plan supplement documents can be resolved by reading the following language into the record. And if Your Honor will indulge me, I'll do that now.
Go ahead.
The agreement to the global debtors and the vendors, consisting of David Yurman Enterprises, LLC, Yurman Retail North America, LLC, Gurhan New York, Incorporated, Carrying Americas, Incorporated, LVMH, Moet Hennessy, Louis Vuitton, Incorporated, Richemont North America, Incorporated, and Interlaced Holdings, LLC, and each of their affiliates, brands, and maisons, other than Louis Vuitton USA, Inc., collectively referred to as the vendors. The vendors do not object to the assumption of their executory contracts with the global debtors under the plan. The executory contracts will be deemed assumed as of the effective date, and the parties will work in good faith to consensually resolve any disputes related to the cure of such contracts with any agreed amounts paid in the ordinary course, subject to the parties seeking further relief from the bankruptcy court in the event the parties are unable to resolve any disputes consensually. And, Your Honor, with that, I think I'm done. If Your Honor has any questions, I'm happy to answer them.
No, thank you very much. All right.
Thank you, Your Honor.
Let's start, Ms. Bordy. Okay. We can't hear you.
Can you hear me, Your Honor?
I can hear you now, yes.
Okay, thank you so much. I just wanted to repeat and reiterate the tremendous amount of work that went into this uncontested confirmation behind the scenes. As I'm sure Your Honor knows, a smooth hearing means, many, many, many hours of work behind the scenes, and the debtors' counsel and ad hoc group worked very constructively with Exonic to resolve the objection that we lodged on the first day of the cases, which we, continued to press throughout the entire case. We are supportive of the plan that incorporates the Exonic settlement that was reached and was filed at docket number 2365, and which will be approved by the confirmation order. And I just had one very small confirmation point that I wanted to make, which, building on Mr. Maranuzzi's painstaking comment with respect to what's being released and what's not being released, I just wanted to make clear there's a statement in the retained causes of action. I think it's clause E that says that causes of action involving HBS Global Properties will be retained. But then there are two more specific clauses referring to the Exonic settlement, which is clause C, and the causes of action related to the HBS lender, which is clause H. Those will be released pursuant to the Exonic settlement and a separate settlement. So just wanted to make that statement clear on the record and express my thanks and appreciation to the debtors, the ad hoc group, and committee counsel.
All right, thank you. Mr. Ghilardi?
Thank you, Your Honor. I just wanted to make 2 points. One, Mr. Metrick does still consider, is still objecting, and I would like to ask Mr. Weinstein about 20 questions in support of that objection.
All right, well, let me get the other people, and then I will come back to that. Okay, so Ms. Raviel?
Thank you, Your Honor. For the record, Jennifer Ravelli of Kelly Dry. Can you hear me, Your Honor?
I can.
Thank you, Your Honor. We filed objections at docket number 2524 and 2550. Your Honor, I just rise to acknowledge our appreciation for both the Wilkie and the MoFo teams in working with us over the past few weeks through many calls and emails to get where we are today. I'm pleased to note that the plan embodies changes that SAC, their lenders, and the committee has agreed to that address all of the concerns listed in our objection. The only exception to that, of course, is cure, which Ms. Sinclair mentioned, and we'll endeavor to resolve that promptly post-confirmation. I just wanted to note that in reviewing the revised plan confirmation order that was filed overnight, our team has identified some language that needs to be modified to align with the settlements embodied in the plan. We've already reached out to the Wilkie team about this, specifically Mr. Brandt, who I believe is sort of the keeper of the confirmation order, and we're confident we can get that wrapped up quickly. But I just wanted to note on the record that it is a live issue. I'm happy to walk through the details of the changes that remain to the plan to address our concerns at any point in this hearing if you have any questions. Otherwise, that's all I have.
All right, thank you. All right. Mr. Prosock?
Thank you, Your Honor. Jeff Kostock for Salesforce. Your Honor, we do not have an objection to the plan. It's a reservation of rights. Salesforce has a number of pre-petition contracts that were entered into with the debtors. The parties have been working to resolve issues with respect to cure amounts. Those contracts are going to be assumed. There's still some discrepancy between the actual list of the contracts that are going to be assumed and the cure amounts, but the parties are continuing to work to resolve those issues. They're large contracts, Your Honor, and important to both the debtor and Salesforce. And what we're asking for, and what I think the plan provides, and what we're hearing today, is that both the debtor and Salesforce will reserve all of their rights with respect to the assumption and assignment requirements under 365, including the cure amounts. And you know, with that reservation and assurance, we support confirmation.
All right, thank you. All right, Mr. Holzefeld?
Good morning, Your Honor. Safety National is the global debtors general liability insurer and the provider of various other policies, commercial auto and workers' comp. To be clear, Safety National supports confirmation of the plan and assumption of the policies as provided in the plan. We simply have one minor issue, actually one line of the plan we believe is incongruent with the law and the intent of the plan. We attempted to work out language in the confirmation order, but we didn't get all the way there yesterday with debtors. I don't actually think there's a legal disagreement, which is all the more the reason it's surprising we couldn't get there. If Your Honor would turn to Plan Section 7.16.
Hold on, give me a minute. What page is that on?
Oh.
I'll find it. Hold on.
96 on docket number 2652, Your Honor. My PDF page 107.
7.6, did you say?
7.16.
1.6, okay. Okay.
About halfway through that paragraph, there's a line that starts, such, sir.
Yeah.
And it reads, such, sir, shall be considered satisfied pursuant to this plan through allowance of the general unsecured claim solely up to the amount of the applicable, sir, or deductible. So this is not a unique issue, Your Honor, and this court's looked at this many times. Off the top of my head, Judge Lopez in the NBC International case, Judge Jones in the Valeris case, the Taylor Brands case with Judge Isger. So courts have consistently held that the SIR satisfaction is a policy term, and whether a particular claim satisfies the SIR is a policy-specific inquiry and a claim-specific inquiry, and that's all appropriate for the state court. I think what the debtors are trying to do with this language is get a finding that their financial obligations to claimants are satisfied with claim allowance, and we don't disagree there. What we do disagree with is that the policy term is satisfied by allowance of a claim. Those are different issues, and there's a potential waterfall of issues that arise between safety and claimants that are seeking coverage and safety and debtors if a policy term is triggered. So all we're looking for is one addition to the plan or the confirmation order that says satisfaction of the SIR and Safety National's policies is subject to the terms of the policy and applicable law. Thank you, Your Honor.
Right. Ms. Sinclair?
Your Honor, if we could be heard quickly on this point, suffice it to say, I think all of Safety National's rights are adequately reserved under the plan, but my colleague, Mr. Brennan, will address this specific objection.
Okay.
Good morning, Your Honor. So first, I'll just note that Safety National did not file an objection to the plan. They raised this issue with us yesterday. But notwithstanding that, we're willing to address this. In our view, Safety National's language that they've been proposing over the past day has attempted to inject a substantive issue into plan confirmation, and it's not necessary to do that. As we understand it, Safety National's concern is that they would like to make an argument potentially in certain cases that, as counsel for Safety National acknowledged, is grounded in the terms of the specific policies. And as he also acknowledged, it's something that's been addressed by different courts. So this is a hypothetical future argument that is dependent on specific policy language, certain jurisdictions, certain specific claims, and will have to be adjudicated on a case-by-case basis. This is not a universally applicable principle that is in any way contradicted by the plan language. So under those circumstances, the global debtors' view is that the appropriate way to deal with this concern is not to have a debate and address in the plan confirmation order that potential hypothetical argument, but rather to make sure that all of the parties' rights are adequately reserved. And that's exactly what we've done. So if Your Honor looks at a couple of sentences down in the same provision of Section 7.16, it writes, for the avoidance of doubt, nothing herein or in the confirmation order shall modify or impair any of the global debtors' insurers' rights to be reimbursed or paid in the ordinary course according to the terms of the applicable insurance policy, including without limitation with respect to any amounts owed to the global debtors' insurers under an applicable self-insured retention. That language, from our perspective, adequately reserves Safety National's rights. It addresses Safety National's concern that, as Mr. Holzapfel said, they want to be able to make any argument as to what the policy says and what rights they have under the policy. We had discussion about this yesterday, and Safety National indicated that language was not clear enough for them. We disagree, but in the interest of resolving this, we added language to the confirmation order that specifically reserves Safety National's rights. And this is paragraph 197 of the proposed confirmation order at docket 2655, page 101. The language that we added there reads, the rights of the global debtors and of Safety National Casualty Corporation relating to or arising under any insurance policies that have been issued at any time by Safety National to the global debtors or any of their predecessors, and all agreements, documents, and instruments related thereto, including but not limited to any defenses to coverage arising under the Safety National policies, are expressly reserved and not modified or impaired by any of the terms of the plan, including, without limitation, and for the avoidance of doubt, Section 7.16, which is the section that we were just reading. So, Your Honor, from our perspective, the rights of Safety National and any other insurance carrier here are sufficiently reserved very clearly. This is an issue of interpretation of policies. If Mr. Holzapfel is right that there is an argument to be made under an applicable policy as to how the self-insured retention is exhausted, the plan and the confirmation order are very clear that they reserve the right to make that argument at any time. If he's not right and that's not supported by the policy, then this is irrelevant, and there's no need for any additional language.
All right.
So, Your Honor, we would submit that the existing language in both the plan and the proposed confirmation order sufficiently address this concern.
Mr. Holzapfel?
Yes, Your Honor. For the record, Safety did file an objection and joinder to the Chubb insurance objection at docket 2614, and that does appear on today's agenda. As far as the substance of their argument, I can just see the state court, Your Honor, looking at this plan and reading that line and saying, well, right here I see that the SIR is satisfied by allowance of a claim. It does not sound like we disagree legally, that whether the SIR is satisfied is a policy issue. All I'm looking for is clear language I can point, or Safety can later, really defense counsel and state court can later point to in the confirmation order that says satisfaction of the SIR and the Safety National policies is subject to the terms of that policy and applicable law. I didn't hear anything in that argument that disagrees with that point, and frankly was not given a reason yesterday or today why that language is not an acceptable resolution of this issue.
Yeah, I think...
If I could briefly respond, Your Honor?
Yes.
So what Mr. Holzapfel is proposing is delving into a substantive issue. It's delving into this issue of whether the SIR in this particular case for this particular policy in a certain jurisdiction is governed by the terms of the policy. And we understand his argument is it is governed by the terms of my policy, but each policy is different, and each policy may say something different about a self-insured retention or a deductible or any other provisions. And so going so far as to say that the Safety National policies, that the self-insured retention is governed by the terms of the policy, yes, to a certain extent that's true, but we are starting to delve into an issue that Mr. Holzapfel at the beginning of this argument needed to cite examples of cases that have delved into that issue, and I think he would admit have not done so consistently. And so this is, again, delving into a substantive issue in a way that is not necessary. If he's right that the policy supports this argument, then there can be no doubt that his right to make that argument is preserved clearly both in the plan and in the confirmation order.
Yeah. Why don't we add a sentence to paragraph 197 that says, notwithstanding anything herein or in the plan, all of Safety National's rights under the policy are reserved, and leave it at that.
That would work for the global debtors, Your Honor.
I defer to Your Honor if you think that addresses the issue sufficiently.
I think it does, and I don't think it tilts it one way or the other, because your policy is being assumed, so it comes with all of your rights under the policy.
We agree, Your Honor. We don't think anything in the plan can modify an executory contract, and so. Right. All right. Thank you, Your Honor.
All right. So
thank you, Your Honor.
I think Ms. Vesper, you may be the last. Mr. Fleischer. Ms. Vesper and Mr. Fleischer.
Good morning, Your Honor. Margaret Vesper of Ballard Spahr on behalf of certain landlords. I won't repeat the full list again to save some time. I echo the comments of Ms. Ravelli. We appreciate the global debtors working through the issues that we raised in the objection filed at docket number 2545. We are continuing to work with the global debtors to finalize issues surrounding the Somerset Saks location, and we otherwise look forward to working through the cures with the global debtors post-confirmation. Otherwise, we thank the global debtors for working with us, and we're continuing to review the revised proposed confirmation order to ensure that it aligns with the changes made to the plan to resolve our issues with the plan. And I'm happy to answer any questions Your Honor may have.
All right, Mr. Fleischer? I have no questions.
Good morning, Your Honor. Can you hear me okay?
I can.
Okay, great. Again, for the record, Scott Fleischer on behalf of landlords affiliated with Urban Edge Properties and Westfield LLC. We went through the revised plan and confirmation order and just had one remaining issue, which is really an adequate assurance point, which was that the plan and confirmation order refer to the revesting of assumed leases in the global debtors on numerous occasions, which would be fine with our clients. However, there's broad rights in the restructuring transactions concept and the restructuring steps plan concept as well that make it clear that there's a lot of flexibility in terms of the go-forward corporate structure. So we sought some clarity as to what that would look like and whether the leases would remain at the same entity and the same general structure going forward, and weren't able to get a sort of clear answer on that. So we had proposed some language saying that the restructuring transactions couldn't violate the terms of an assumed lease, just to try and get some clarity there, and that don't believe was acceptable. We were on some emails, just prior to the hearing as well, trying to work something out, but that was our concern, right? That you can't start moving entities around, without notice and an opportunity to be heard from an adequate assurance perspective.
All right, Ms. Sinclair.
Apologies, Your Honor, we were on mute. Deborah Sinclair will keep bar for the record. Your Honor, I don't think that we can, from an administrative perspective, agree to Mr. Fleischer's language in the sense that it would require me to review every single unexpired lease we have and make sure there's no footfall. But I think that there's nothing in our plan that would allow the company to override the provisions of any lease post-emergence. We assume any lease we assume, subject to all of the obligations the global debtors have thereunder, and any counterparty to those assumed contracts and leases will have whatever rights and remedies they have against us if there's a world where we were to violate any of the provisions of those contracts. So I don't think there's any end run being proposed around either 365 or any of the provisions that would live inside the leases of Mr. Fleischer's clients. As to the illusion that there is an adequate assurance issue, I think our disclosure statement shows that the debtors are going to be significantly well capitalized following the emergence. No one, including Mr. Fleischer, has raised any objection to that concept. So that, candidly, to me, is a new issue. But as it relates to assumption and assignment, we've satisfied the requirements of the bankruptcy code, and to the extent there was a post-emergence dispute, the parties' rights are reserved.
Your Honor, may I respond?
Yes, go ahead.
Sure. I'm not concerned about the global debtors from a, no pun intended, global perspective, financially speaking. There just needs to be some clarity as to what the go-forward corporate structure will look like, just to make sure that the tenant entities that our clients have under the assumed leases are in a similar position to where they are now. And besides the post-effective date issues, if there are some transactions that take place to prepare for the effective date, post-confirmation, but pre-effective date, again, there's broad language in there that there could be assignments and other sort of corporate transactions that take place. So again, just looking for some certainty that the structure is going to remain generally as is.
Well, I'm generally not going to limit the ability of the debtor to have, a more tax-efficient corporate structure of those kinds of things. I think you reserve all of your rights, and to the extent that, you think that those rights have been violated, obviously you can come back to court and say that. But to basically, limit what steps the debtor can take to, have a more tax-efficient organization, or to, eliminate unnecessary subsidiaries, those kinds of things that really, at the end of the day, have no particular impact. I don't think we can, we can kind of hamstring the debtor. So I understand the nature of your objection, but I think that if your lease is being assumed, you retain all of your rights, and to the extent you think that at some point the debtor does something that is, either in violation of the lease or would have changed the adequate assurance or calculus, then I think you're free to come back to court. So
with that position, I'm fine to rest for now. Thank you.
All right, thank you. All right, Mr. Feinstein. Mr. Feinstein, I can't hear you. Are you muted? No, I can't hear you. Hit 5-star. All right, is that you?
Thank you, Your Honor.
Okay.
Yes. Sorry about that. For the record, Ben Feinstein. There's somebody with background noise.
No.
Okay. For the record, Ben Feinstein, Quinn Emanuel, on behalf of HB Strategies, Your Honor. So, Your Honor, for about a week now, we've negotiated language that would obviate the need to object to the plan. The language is found in paragraph 185 of the proposed confirmation order. I could share my screen, Your Honor, or if Your Honor is looking at it, then obviously there's no need to share. In any event, the language was acceptable to my client. It was acceptable to the debtors in possession, and it was, in fact, acceptable to the Statutory Creditors Committee. Last night, without any notice to me, there's a red line filed to paragraph 185. It has some language at the end, and not only was it without any notice to me after an agreement, but it has the powerful language of saying notwithstanding anything herein to the contrary. And so it basically overrides all of the work that I really appreciated doing with the debtors leading up to today. Your Honor, in an effort to be constructive, what I would propose is that I don't really object to this language, provided that the debtors in possession and the creditors committee both affirmatively agree that the effect of rejection, that all parties reserve rights with respect to the effect of rejection. And what I mean by that, I'll be more specific, is just that a debtor can reject a contract. That's a business judgment issue. It's not an issue I planned on contesting. But to the extent I had property interests granted to me under that contract, which I did, rejection doesn't eviscerate property interests, as Judge Isger recently held, not so recently anymore as time goes by, but recently held in Sanchez. And so if they're going to put this language in that says the contract will be rejected to the extent it's executory, I'd like it not to override the general reservation of rights that we all agreed to about what this plan does to my property rights and to the contract. So I would wait to hear from the debtors in the committee whether or not they agree to this proposition. I don't like doing things this way, Your Honor, but this was red line filed on the docket either last night or this morning. I didn't have any notice about it.
All right, Mr. DePampio.
Your Honor,
Yeah.
Good morning, Your Honor. Christopher DePampio of Wilkie Farr & Gallagher for the Global Debtors. Your Honor, we actually thought that this language was going to be pre-cleared with the participant. It wasn't. That was an oversight. We have no problem with adding the additional language Mr. Feinstein has asked for. Our position is, I think we actually are in agreement on this, that everybody is reserving rights with respect to the plan. These issues are going to be dealt with later, and the effect of rejection and whatever that may be will be decided at a later time. I believe we may have language to add to the order.
We're just going to say on the record.
Which we'll just actually, I guess we'll just make these representations on the record. So I think that is where we are. We should hear from the creditors committee, but I believe they're also in agreement.
Hi, Your Honor. Can you hear me okay?
Yes, I can hear you fine.
Thank you. Again, for the record, Brian Kotlier of Morrison & Forster on behalf of the committee. Your Honor, the debtors change that Mr. Feinstein referred to was news to us this morning. The HBS proposed changes we just heard about on the line were also news to us. We're okay with that, with the concept, Your Honor. The parties had bounced around some language, I think, that would resolve this, either through the representations made on the record or through language that we can agree to in the confirmation order. we're fine with the reservation of rights that Mr. Feinstein outlined. Thank you.
All right. Well,
Your Honor, just to clarify, I believe it was Mr. Butterfield from the Morrison Forrester firm that provided the language. So we may have some crossed wires here, which we'll sort out, but I do actually think the parties are on the same page about the effect of the language. And to the extent we're not, we'll work that out and provide clarifying language to Your Honor.
all right. Thank you. All right. I mean, I think that Mr. Feinstein's stating a pretty uncontroversial law that to the extent you have property rights regardless of your of a rejection of a contract. So, all right, that should get resolved. All right, so I guess any other person wish to be heard?
Thank you.
With respect to confirmation, and otherwise we'll go back to Mr. Ghilardi.
Yes, Your Honor. Can you hear me?
Yes.
Again, Your Honor, for the record, Roy Zur of Elkins Cult on behalf of SF Wilshire BH LLC.
Yep.
Your Honor, briefly, my issue is very limited. I won't take up much of the court's time. Your Honor, my client holds a security against a vacant real property located in Beverly Hills, California. It's adjacent to one of the debtor's flagship stores in Beverly Hills. Your Honor, prior to the, we filed a reservation of rights, that's docket entry 2587. We've been working with the debtors and with the lenders in the background on precise treatment to be given to my client's secured claim, which is claim number 4144. We have been working for several months. I appreciate the efforts by counsel to try and reach agreement on the treatment. We're not there yet. My understanding is that the principals are still talking and trying to arrive at an agreement. Your Honor, right now, my client's claim is addressed in the very last paragraph of the confirmation order, which was submitted this morning, and it's paragraph number 198, and it provides that unless otherwise agreed in writing between SF Wilshire BH LLC and the global debtors on or prior to the effective date, in full and final satisfaction, compromise, settlement, release, and discharge of claim number 4144, on the effective date, SF Wilshire BH LLC, as the holder of such other secured claim, shall receive at the election of the global debtors and subject to the reasonable consent of the required consenting DIP term loan lenders, the collateral securing its other secured claim. The issue we have, Your Honor, is that this is somewhat open-ended and still uncertain as to what the treatment will actually be between now and the effective date. Again, we're trying to resolve this, and my hope is that we will. All I ask, Your Honor, is that there be a reservation of rights at the end of that paragraph that provides that something to the effect of if there is any other treatment selected by the debtors that SF Wilshire BH will reserve all of its rights with respect thereto. I proposed something to that effect last night, and I was and then I was told that this new paragraph was added to the confirmation order, which might address my concern, but for the reasons I just stated, I don't believe it does.
Okay. So it's this paragraph 198, which starts, unless otherwise agreed to in writing?
Yes, Your Honor.
So when I read the paragraph, it's either you agreed to something in writing or they're going to tender the collateral.
Right. We don't have any. Sorry to interrupt. Your Honor, I don't have an issue, obviously. If the paragraph were to state that they actually will do that, I wouldn't have any issue. The problem is that there's that qualifier of at the election of the global debtors and subject to the reasonable consent of the required consenting DIP term loan lenders. It leaves room there for a different decision to be made. And so all I would ask, Your Honor, is that to the extent that such other decision is made, that we reserve all rights with respect thereto.
All right. Ms. Sinclair.
Your Honor, I think there are only two choices here, which I think is the point that you were getting at. So it's a better option is to just cross out these, of purported ambiguity. I would be happy to do that. But from the debtor's perspective, it is either we reach a consensual deal or this creditor will receive the collateral that secures this other secured claim.
All right, so we'll just strike at the election to, so we'll strike at the election of the global debtors and subject to the reasonable consent of the required consenting DIP term loan lenders. I actually thought that was more having to do that the required consenting DIP loan lenders had to agree to your deal as opposed to that they had to agree to something else. But I think that I don't think there's any. Yeah, I think it's either A or B. Either reach a deal, the three parties reach a deal, or you get the collateral. So maybe you can just take that out or clarify it. I don't think this is an issue.
Yes, Your Honor.
That addresses the issue. Thank you, Your Honor.
All right. Are we ready for Mr. Weinstein? Does anyone else have any question? Ms. Strickland, go ahead.
Thank you, Your Honor. Can you hear me?
I can.
All right, I battled the mute button. For the record, Rachel Strickland, Brooks and Gray, on behalf of Richard Baker and Ian Putnam. They are former officers and directors of the Global Debtors, and Mr. Baker's objection was filed at docket 2514, and Mr. Putnam's objection was filed at 2578. We have 4 total exhibits among the two. They're filed at docket 2649 and 2650. And I would note that there are some redactions in there which we redacted at the request of the debtors. So I'd like to move to admit those exhibits into evidence.
Okay.
Yes, fine with the debtors, Your Honor.
Thank you.
All right. So as it relates to exhibit 2649-1 is the consulting agreement, and 2649-2 is the amended consulting agreement, and 26-3 is the notice of termination. So those exhibits will be admitted. And what were the other exhibits?
2650, Your Honor.
Okay, so then these are Mr. Baker's exhibits, and that is 2650-1 is the separation agreement, and that'll be admitted.
Correct, Your Honor. Thank you. So obviously we're at confirmation, but it's important to go back to the petition date because that's what sets the stage for the issues in our objection. For years, Mr. Putnam and Mr. Baker served as officers and directors for more than 30 separate debtor entities that all filed petitions on January 13th. And while the debtors are now, based on their exhibits, going to point to timestamps on petitions, the agreements themselves, as well as both sides' conduct, indicates what these agreements were to provide for. The global debtors, who are the parties that are bound by these consulting agreements, were really directing the run of show for these cases. And in the run of show, what they orchestrated by those debtors was to have Mr. Putnam and Mr. Baker resolve as directors to commence the cases on January 13th and thereafter agree to separate from the debtors on the close of business on the day the cases were to be commenced. So the debtors could have just fired my clients, but they didn't want to because they needed them. And my use of they is very important. Just as over 30 debtors employed and agreed to indemnify my clients, many of them also needed services or covenants from my clients to continue. And this is all noted in the agreements that we filed and the exhibits that we just admitted. In those agreements, Mr. Baker and Mr. Putnam agreed to their termination from the company group and the direct and indirect parents and subsidiaries and affiliates. And in exchange, they accepting ongoing material obligations. And in return, among other consideration, the global debtors expressly reaffirmed and preserved their indemnification rights. So with Mr. Putnam in particular, that agreement provided consulting services of at least 40 hours a week regarding the debtor's real estate portfolio.
He repeatedly met with the creditors committee to help unlock value in these cases by doing real estate deals that are really the crux of the recoveries in these cases. He also agreed to cooperate with these cases. He sat for the special committee's investigation twice voluntarily. He also sat with the UCC. He also agreed to valuable non-compete, non-solicit, and non-disparagement obligations. Mr. Baker, whose agreement is filed as Exhibit 1, also agreed to be bound by valuable non-compete and non-solicitation provisions that went on in some cases for 24 months after execution and in others for 12 months. He also provided documents in response to both the special committee and the UCC's investigation. There's no ambiguity in the agreements. For Mr. Putnam, it says, company group shall indemnify and hold you harmless to the fullest extent permitted by law and the applicable company group's member bylaws or other organizational documents for your good faith actions or inactions as an officer, director, employee, or agent of the company group. And for Mr. Baker, it expressly preserves his right to seek indemnification claims against the company. There's no restrictions on the language. It's not limited to the duration of Mr. Putnam's role as a consultant. It is only as long as Mr. Baker complies with his restrictive covenants. So there was a full reaffirmation of everything that is already provided for in many, many of the debtors' organizational documents. Despite their stepping down from the role of officer and director, the debtors were agreeing to preserve their indemnification rights, which arise under those org docs. And so now, having extracted many of the benefits of the agreement offered to them, the debtors seek to use the confirmation process to strip away the protections they promised in return. And what's their justification for doing so? First, they said in their objection, the response, that the counterparty to the agreement filed a few hours after this was executed. Your Honor, I would submit that this is a gotcha. Even if all of the global debtors filed hours after the agreements were effective, it's difficult to believe that that's really the debtors' position. Did they knowingly enter into an agreement with key executives and directors as they were authorizing resolutions, prepping, and filing petitions with no intention to comply? I don't think that's the case. The debtors, however, are talking out of both sides of their mouth. The next make an argument in their reply that even if these are post-petition agreements, well, Your Honor, they say we should have gotten approval for it and we didn't. That's a really strange argument for counsel to raise now. They amended the agreement a few months ago. They reaffirmed the terms of the original one that remained, quote, in full force and effect. And again, just last month, when Mr. Putnam was sent a revised consulting agreement for more work, nobody talked about seeking court approval at any point. So they can't claim their failure, if in fact what it is, as a defense. Further, if the debtors didn't think the agreement was enforceable, they had a responsibility to say so to the officers and directors who they were advising in the boardroom and just signed resolutions to file these cases. Of course they thought it was enforceable. This is a post hoc rationale. But that's not good faith. That is the use of the bankruptcy process as a sword to cut away obligations that the debtor voluntarily contracted for and benefited from after the petition was filed. And the issue here is whether the debtor can reap the full benefits of a post-petition agreement, one it voluntarily entered into, extended, and relied upon throughout these proceedings, while simultaneously claiming that the agreement is ineffective, stripping away the protections it offered in exchange. And yet, that's exactly what Section 6.4 of the plan does. It permits the debtors to have it both ways. In practical terms, the proposed plan would render meaningless the indemnification protections that the global debtors expressly committed to preserve in the separation agreements after they got all of the benefits of the agreement. Strangely, it also seems to imply, while not saying so directly, that even if the contracts, as they argue, were pre-petitioned and rejected, that my clients wouldn't even have unsecured claims that they could recover on against each of the entities that agreed to indemnify it. That's just not the law. And not only that, it's another inconsistency in the debtor's behavior. At the opening of the hearing, Ms. Sinclair noted that parties that were receiving no recovery on account of unsecured claims got opt-in ballots. Well, my clients got opt-out ballots, which by Ms. Sinclair's own recitation would imply that they were entitled to receive a recovery on account of general unsecured claims. Well, that's not what 6.4 says with respect to their unsecured claims on indemnification. Again, they can't have it both ways. But even setting aside the consulting agreement, Mr. Baker and Mr. Putnam's indemnification rights exist independently under Delaware law. Your Honor, Section 1129A3 requires that a plan be proposed in good faith and not by a means forbidden by law. The proposed plan fails on both counts as it tries to get Your Honor to approve a bait and switch. We're not asking the court to derail the global debtors reorganization. This is not a request for special treatment. It's a request that the global debtors honor the bargain that they struck, comply with the law that governs their corporate obligations, and refrain from using the plan confirmation process to accomplish what they could not lawfully accomplish outside of bankruptcy. So we respectfully ask that the court sustain this objection and require the appropriate modification to the proposed plan that honors Mr. Baker and Mr. Putnam's indemnification obligations against each of the debtors. Thank you, Your Honor.
All right, Ms. Sinclair.
Yes, Your Honor. Mr. DePompio will be handling the argument on this point.
All right.
Good morning, Your Honor. Christopher DePompio, Volpe Farr & Gallagher for the Global Debtors. I do intend to respond to Ms. Strickland's argument. Obviously, we completely disagree with both the law and the description of the facts on that. But I do know Mr. Ghilardi had some questions for Mr. Weinstein. I don't know if it makes more sense to proceed with that first and then come back to argument after.
All right, we can do that. So is Mr. Weinstein available?
He is, Your Honor. See if we can make it work on the camera here.
Okay.
No, he's from here.
Oh, sorry.
All right, Mr. Weinstein, would you raise your right hand? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right. Go ahead, Mr. Ghilardi.
Thank you, Your Honor. Mr. Weinstein, have you reviewed the confirmation brief?
Yes.
Okay, and is it your understanding that Mr. Metrick and we'll add Mr. Baker and Mr. Putnam will have only pre-petition claims for indemnity?
Yes.
And is it your understanding that those claims will or will not, what is your understanding of whether those claims will or will not receive a distribution as a pre-petition unsecured claim?
Just a minor objection, Your Honor. I have no problem with Mr. Ghilardi asking for the witness's understanding, but just want to also note to the extent it calls for a legal conclusion about what the documents actually provide for, the witness isn't competent to testify on that.
Okay. Go ahead and answer the question if you can, Mr. Weinstein.
I'm sorry, can you repeat the question?
Will Mr. Metrick, under the plan, in your understanding, receive a distribution on account of any pre-petition unsecured indemnity claim?
I'm not certain.
Okay. And Mr. Weinstein, do you have an understanding that certain directors and officers have indemnification claims that will be paid in full under the plan?
I don't know what claim. I'm not aware.
Do you know if any directors and officers will be indemnified for any investigation done by the UCC in connection with potential claims given to the liquidation trust?
I'm not certain. There's D&O insurance. I don't know what claims could be brought against them, and I don't know whether they'd be covered.
Well, do you know if they will be indemnified Do you understand that the debtors have said that they will be paying certain directors and officers indemnification claims under the plan?
Certain? Yes.
Okay. And would those claims, in your mind, and again, not as a legal conclusion, also be unsecured pre-petition claims if they relate to events that occurred prior to the petition date?
Same objection, Your Honor.
I'm sorry, I'm not sure I understand the question.
If there's an investigation with respect to events that happened prior to the bankruptcy case, and those claims are indemnified, are those pre-petition claims in your view?
If they occurred prior to the filing, in my view, yes.
Okay. And are those claims being paid in full for certain officers and directors?
I'm not in a position to answer that now.
Do you know the names of any directors and officers who are receiving full payment on account of their pre-petition, on account of indemnification for pre-petition claims?
And just, Your Honor, I just want to make a standing objection to the extent the witness is being asked to give a legal conclusion. He can't do it. Obviously, Mr. Glardy can ask about his understanding, but with that clarification, I don't want to interrupt things by objecting every time, if I could have that indulgence.
Yeah, I'll give you a running objection. Go ahead, Mr. Weinstein.
Thank you.
I'm sorry, can you repeat the question, please?
Mr. Weinstein, do you know the names of any officers and directors whose indemnification claims will be paid in full under the plan of reorganization?
Again, without knowing the nature of the claims, I don't think I can actually, answer that question completely.
Okay, and do you know of any consideration that any such officers and directors gave to the company in exchange for having their indemnification claims paid in full under the plan?
Not aware.
And do you know if any of those claims would fall within the Class 4E of the plan of reorganization?
I don't recall what 4E is off the top of my head.
Do you know whether if Mr. Metrick's unsecured indemnification claim fell in 4E, would that ring any refresh your recollection at all?
No.
Okay. I have no further questions, Your Honor.
All right. Any redirect, Mr. DiPompeo?
No redirect, Your Honor.
All right. All right. Thank you, Mr. Williams.
Your Honor, may it be?
Yep. Go ahead. Go ahead, Mr. Ghilardi.
Your Honor, it may be good for me to place my objections along with Ms. Strickland's on the record now so the debtors can reply to them all at once, if that works.
Yep.
Thank you, Your Honor. First, I would join in Ms. Strickland.
Sorry, Mr. Ghilardi, can I just clarify that the witness is excused with the court? So.
Yes.
Yes. Go ahead, Mr. Thank you.
Thank you. Your Honor, in addition to Ms. Strickland's objections, and Mr. Metrick had entered into a separation agreement that was negotiated by Mr. Baker about 10 days before the filing, we would add the following objections. Your Honor, in their confirmation brief, they argue the following. First, that preemption, that there is a conflict between Delaware law requiring that the indemnification obligations be honored, whereas the bankruptcy code will treat them all as a pre-petition claim. With respect to that objection, if the debtors do in fact believe that, then every one of the indemnification claims, whether they were from Mr. Metrick, Mr. Baker, Mr. Putnam, or any other director and officer, would all be unsecured claims. Your Honor, there is, with respect to such unsecured claims, therefore, when you look at classifications of plans for bankruptcy code, it is the classification of claims, and they must be treated similarly unless the debtors give a reason for treating them separately. Importantly, the plan does treat our unsecured claims, Mr. Metrick's unsecured claims, but there is no class that has been established for the indemnification claims of any other directors and officers to give a treatment. In that sense, what I would say is if Your Honor thinks about critical vendors, it's often case in plan that you'll have certain vendors become general unsecured creditors and other vendors become critical vendors and they will get separate treatment. There is no such classification here, and by the preemption argument, all of these claims are pre-petition claims, and so we would argue that there is a failure to classify these claims in a plan. So our first objection is a confirmation objection. Second, Your Honor, we would argue that with respect to the directors and officers, as Mr. Weinstein could not identify and did not identify, we would also argue that treating those individuals differently without a consideration violates 50C. So we would also argue that the plan violates 50C by treating those forward directors, or whether they were critical to the reorganization, that they are insiders by definition, directors and officers, and therefore we think that the plan violates 503C. So for those reasons, while we would just ask for a modification of the plan to make sure that either the indemnification claims of all people are treated the same, reserving all rights to argue on a claims objection that we too have provided post-petition benefit under the separation agreement that the debtors had accepted, and that we have administrative claims that arose during that period.
All right, thank you. All right, Mr. DePompeo.
Thank you, Your Honor. Christopher DePompeo, Wilkie Farr and Gallagher for the Global Debtors. Your Honor, before I respond to the arguments, I would just like to confirm that the evidentiary record is now closed on confirmation, and ask if there's anyone else who has an objection to that.
Yeah, is anyone, yeah, it's a good point. Does anyone have any additional evidence or argument? All right, so the record is closed.
Great, thank you, Your Honor. So, Your Honor, as you've heard already, the arguments here from these former officers and directors are all focused in Section 6.4 of the plan. As you probably know or have heard, Section 6.4 provides full new indemnification obligations for the go-forward officers and directors and personnel, but it limits indemnification for former officers and directors to the extent of insurance proceeds. That's a very standard provision in plans, and we'll go through that. The objectors believe that this isn't sufficient, and that instead of this, in addition to the insurance, the plan must also provide them with a broad indemnification on a 100-cent basis for their pre-petition claims. We think that's wrong. I actually think that's obviously wrong for a lot of reasons, and we'll discuss those. But I do think before we get into the specifics of the arguments, and I do intend to respond on all of the specifics, I do think it's worth making some broader points that I think will frame the discussion and put this some context around what we're thinking about here. At 4 points. First of all, I think it does need to be observed that this is a really extraordinary request that's being made here. All of these officers and directors essentially claim that the reorganized debtors have to pay 100 cents on any pre-petition indemnification claim, dollar for dollar. I think that itself is an extraordinary request under the Bankruptcy Code and its treatment of pre-petition claims. But I think it's even more extraordinary when you consider who the objectors actually are. These are all former officers and directors who are excluded parties under the plan and were not given releases under the plan. And so this means that they may be subject to estate claims and causes of action. Those estate claims and causes of action have been given to the litigation trust, and my understanding is the litigation trust intends to pursue those claims and causes of action. Obviously, the answer can't be that if the litigation trust succeeds in pursuing a claim against one of these officers and directors, and they have to pay money to the litigation trust, but then there is then a dollar-for-dollar rate of reimbursement from the reorganized debtors on these estate claims that used to be the reorganized debtors' claims. That doesn't make any sense. It's so circular as to be self-defeating. And I think the circularity of the arrangement that's being proposed here, I think, is enough to suggest and show that that can't be the answer. Whatever the arguments are, we've got a lot of arguments, that at the end of the day cannot be the answer under the Bankruptcy Code or applicable law. The second thing I'd say is that there's nothing unusual about this plan that would suggest there should be an unusual result like the objectors propose. To the contrary, plan provisions providing full indemnification to go forward officers and directors and limiting indemnification to insurance for former officers and directors are very commonplace. We did a very quick skim of cases in this court just over the last couple months and found at least 4 cases with similar provisions, including PPI Composites, OPI, Everstream Solutions, and Luminar. It's a very common concept. And of course, also the concept that estate causes of action could go into a litigation trust and ultimately fund unsecured creditor recoveries is also extraordinarily common. In fact, those causes of action are often the primary or a primary source of unsecured creditor recoveries. Which I think brings me to my third point, which is that many of the arguments that are being made here are not specific to this case. They would apply in every case. So, for example, the DGCL arguments that have been articulated that the Delaware General Corporations Law, Section 145, actually requires a reorganized debtor in every case, whether it's a Delaware corporation, of course, to pay dollar for dollar indemnification claims, would apply in every circumstance. It's not limited to this case. And I think that would pose real challenges to decades of bankruptcy practice that has grown up and the practice of giving estate causes of action to litigation trusts to fund unsecured creditor recoveries. Again, I just don't think that can be the answer. Finally, and this is more specific to Mr. Baker and Mr. Putnam, and I'll respond to all of Ms. Strickland's arguments as we go through this. But I think it is, just at a very broad level, important to say that it is clear that these contracts were pre-petition agreements, and it's also going to be clear as we go through this that they don't actually even give the indemnification rights that Ms. Strickland has said they do. But just stepping back from that, the notion that the debtors could, in a post-petition basis, give full, uncapped, dollar-for-dollar indemnification claims to insiders, particularly insiders who are going to be the principal subjects of a special committee investigation, a UCC investigation, and potentially litigation trust claims. The notion that the debtors could do that without court approval, I think, is absurd. I have worked with the Morrison Forrester team for 6 months now, and I can assure you, based on that experience, that they would have wanted to be consulted and heard on that issue had this actually been a post-petition agreement. I'm also confident that Your Honor would have wanted to weigh in and evaluate whether this was an appropriate use of the state resources. The reality is that fact demonstrates that these were pre-petition agreements. They were never intended to be post-petition agreements. And I think more broadly, even if Ms. Strickland prevails on all of her arguments, I think they're wrong, but granting everything that she says in her brief, it still is the case that those agreements, even if she were right, would be unenforceable because they weren't approved by the court. So those are the preliminaries. I think the bottom line is that there's just no way former directors and officers can walk out of here with full dollar-for-dollar indemnification claims against reorganized debtors. That would completely gut the plan and is not required by the law. Let me get into specifics. I will try to move quickly. I know it's been a long hearing already. I will do my best. We'll start with the Metric objection first. As you've heard, Mr. Metric's objection is that Section 6.4 of the plan violates Section 1123A4 because it treats him differently from similarly situated creditors. The first group Mr. Metric points to are the current DNOs. And as we've discussed the way the plan works, current director and officers that go forward team for the business are fully indemnified. Former directors and officers who have no role with the business are not. They're limited to insurance. And at a basic level, I think it fails because those two groups are not similarly situated. The go-forward directors are all released parties under the plan. They're critical to the reorganized debtors' successful emergence from Chapter 11, and they're providing ongoing services to the reorganized debtors. By contrast, Mr. Metric and the former directors and officers are not released by the plan. They provide no ongoing services, and they're not in any sense critical to the reorganized debtors' success. They're not similarly situated, and so 1123A4 doesn't require them to be treated equally. In addition, the go-forward directors and officers, and I think this is a point of misunderstanding on the plan, they're not receiving their indemnity on a go-forward basis on account of their pre-petition claims. They're receiving it on account of the fact that they are go-forward directors and officers who are providing services into the future. These are new obligations that are being imposed by the plan, and the plan can do that going forward. I think it's well within the reasonable business judgment of the reorganized debtors to provide a broad indemnity for their critical officers and directors who will take them through this next chapter of their business, and we don't see any problem with that. Mr. Metrick also argues the plan treats his claims differently than other general unsecured creditors. Mrs. Strickland actually also echoed this argument during her argument. I think this is just based on a misreading of the plan, so hopefully we can deal with it easily. Mr. Metrick's argument seems to be focused on the provision of the plan that says the reorganized debtors will have no out-of-pocket liability for former D&O indemnification claims. That's in Section 6.4. But that's true of all general unsecured claims. No general unsecured claim is the reorganized debtors are not going to have to come out of pocket for any general unsecured claim. All of those claims are being channeled to the litigation trust. And Mr. Metrick's claims and the claims of the former officers and directors are likewise being channeled to the litigation trust. Now, the litigation trust, of course, may have defenses to those claims. There are all sorts of defenses they may seek to assert, but their claims themselves are being treated no differently than anyone else. So I do think, and actually in reality, those claims are in many ways better off than most general unsecured creditors because they at least have access to the insurance proceeds. So I think that's an easy argument to reject. Third, Mr. Metrick and Mr. Baker and Mr. Putnam all argue that Section 145 of the DGCL actually mandates that the company maintain its indemnity obligations. This is the argument we discussed earlier. For one thing, it's not even clear to me that DGCL applies because, as I understand it, Mr. Metrick's, Mr. Baker, and Mr. Putnam's claims were only filed against LLCs and one limited partner. Obviously, the Delaware General Corporations Law only applies to a corporation, so I'm not sure it even applies. But also, DGCL Section 303, which wasn't cited by any of the parties, actually grants the debtor in possession very broad authority as when it's a debtor in bankruptcy to carry out orders or decrees of the court, to alter or amend its bylaws, and to do other things necessary to be a debtor in bankruptcy without needing to comply with the formalities of Delaware law. I actually think Section 303 does exactly what you would hope and expect state law does. Obviously, a lot of Delaware corporations are here. It preserves the ability of those debtors to work within the bankruptcy system, which is a federal system, without state law requirements getting in the way. That section allows the debtors to comply with the provisions of the plan and the confirmation order without having to worry about what Section 145 might otherwise apply outside of bankruptcy. The law works just as you'd expect it to. And obviously shouldn't be interpreted in a way that undercuts a federal scheme. I do think that it's still true, though, that even if that wasn't enough, and I've dealt with this issue a lot, it is black letter law that the Federal Bankruptcy Code preempts inconsistent state laws. And so even in a world where DGCL 145 did actually require organized debtors to pay 100 cents on the dollar claims for pre-petition indemnification, which again, I don't think is the world, but if that world did exist, then it would clearly be preempted by the Federal Bankruptcy Code. It's inconsistent with Section 1141B, discharge provisions, and also Section 502E1B, which actually requires disallowance of those claims when they're contingent. So that's it for Mr. Metrick's objection, also for much of Mr. Baker and Mr. Putnam. So we are making progress, Your Honor. Have no fear. We are closing in here on the end. The rest of Mr. Baker and Mr. Putnam's objections actually focus on their individual separation agreements, and this is where Ms. Strickland spent most of her time, and so I'll respond to these points. The main argument seems to be that these agreements separately and independently provide indemnification, and that they're post-petition agreements that cannot be rejected and must be honored. We obviously disagree on each one of those points, and really for at least three reasons. I might ask quickly, Your Honor, if we could allow Ben Hewitson to share his screen. He has raised his hand. Perfect. Thank you. And we'll get to Ben in just a second, but the first reason we think that's wrong is just on the face of the contracts themselves, there's not a broad indemnification right. We'll pull up Richard Baker's contract. It's Exhibit 1 on the Baker exhibit list. It's filed at docket 2650. I don't know, screen share access. You have screen share?
You don't?
Okay. He does not, Mr. Hewson.
Okay. Raise your hand again. Can you turn on your camera real quick? Okay, you're a presenter now. Go ahead.
Great. Thank you, Your Honor. So Mr. Hewson is going to pull up Exhibit 1 on the Baker exhibit list. It's filed at docket 2650-1. This is in evidence. And this is Mr. Baker's separation agreement. There it is. Great, thank you. Let's look at Section 3 on page 4. It is Section 3E, that is 3E4, in fact, that is the source of Mr. Baker's supposed indemnification claims. Let's start at Section 3, the top of Section 3, because this section is titled Release and Waiver of Claims. A is a definition. B then provides a very broad release of claims from Mr. Baker against the company. Let's scan down. I just wanted to point that out. We'll go to the next page, page 5. And more release provisions, more understanding provisions, those kind of things. When we finally get down to Section E, you can see that Section E is a carve-out. It's a carve-out from the release. The relevant language here that Mr. Baker points to is Romanet 4, IV, little IV. And it says, starting at the top of that paragraph, notwithstanding any provision of this agreement to the contrary, by executing this agreement, you are not releasing any claims relating to, breakdowns of Romanet 4, your right to indemnification in accordance with and subject to the company group's governance document. So what this is it's just a carve-out from a release. It's just saying that although Mr. Baker was releasing claims, it's clarifying that he's not, by this document, releasing any indemnification claims he otherwise might have had under his pre-petition agreements, or pre-petition organizational documents. The separation agreement itself really adds nothing. I mean, Mr. Baker is squarely in the position of Mr. Metrick's clients. There's nothing additional that comes to Mr. Baker from the separation agreement. I think that's a very important point to make. Thank you, Mr. Hewson. You can stop sharing your screen. Now, Mr. Putnam's agreement is a little different. It's a consulting agreement. I don't think it's necessary to pull it up. The agreement does give indemnification rights as part of that consulting arrangement. It also pays Mr. Putnam very handsomely for his consulting services, and includes a termination provision which allows the debtors to terminate at their election and provides they'll have no further obligations going forward from that. I don't think we need to pull that up, but just for your reference, it's on page 2 of the agreement, which is Exhibit 1, Putnam's exhibit list, docket 2649. And as has been put into evidence already, the debtors have terminated that agreement. So at least for Mr. Putnam, there is no go-forward long-term indemnification obligations. Moving on, and this was really the central focus, I think, of the objection that was filed, is this idea of whether the agreements are pre-petition or post-petition. I think they're clearly pre-petition. And we think everything that is argued by these directors really turns on this question, in addition to what we just said. Both Baker and Putnam's agreements, and I'll do this quickly because I don't think it's all that controversial. Mr. Baker and Mr. Putnam's agreements are dated January 13th. As Ms. Strickland argued, there's a provision, Ms. Strickland argues that the agreements were effective as of the close of business on the 13th. But as the records of the court show, and the court can take judicial notice, the first debtors didn't start filing until 10:37 p.m. Central Time on the 13th. And the debtors who are the signatories to the Baker and Putnam agreements didn't file until later. Putnam is actually very easy because Putnam's agreement is clearly dated the 13th. The only signatory to that is Sachs Global Enterprises, SGE. And SGE didn't actually file its bankruptcy petition until 12:22 a.m. on January 14th. And so it's very clear. Agreements on the 13th, filed a petition on the 14th. It's obviously a pre-petition agreement. The Baker agreement has two signatories, SGE and Sachs & Co. Sachs & Co. actually filed at 11:54 p.m. Central Time on the 13th. But I think any reasonable interpretation of the phrase close of business is before 11:54 p.m. That's clearly after the close of business. There doesn't seem to be any disagreement that if these contracts are pre-petitioned, they're rejectable, and that was appropriate and proper, and so we think that's also case dispositive. And third, and this is the point I made earlier, I think stepping back, I mean, all of the facts and circumstances surrounding these agreements suggest that they were pre-petition agreements, and that the debtors did not intend to give away broad indemnification rights in a post-petition manner. But even if they weren't, even if somehow Ms. Strickland convinces you that the agreements actually do provide independent indemnification rights, which I don't think they do, even if she convinces you that they're post-petition agreements, you still have the problem that these agreements were not approved by the court, and there's just no way that it can be the answer that the debtors could give broad indemnification rights that undercut the litigation trust framework and structure that evolved around this plan in that manner. So any victory by Mr. Baker and Mr. Putnam, I think, would ultimately be Pyrrhic, and it would result in unenforceable agreement. Again, there's no long-term indemnification obligations coming from this. Okay, last argument that is raised here is Baker and Putnam's argument that the plan wasn't proposed in good faith because the global debtors are not providing indemnification as Mr. Baker and Mr. Putnam supposedly expected. I don't think this argument needs to detain us for too long. Both Mr. Baker and Mr. Putnam were represented by counsel. There's references in the agreement to them having counsel and being urged to seek counsel, and they were, in fact, represented by counsel. They knew a bankruptcy was soon to be filed. That's also all throughout the agreements. They should have known, based on discussions with their counsel, that pre-petition agreements are not enforceable unless assumed. They should have known that post-petition agreements are not enforceable unless approved by the court. And there's really no way they could have had any reasonable expectation in those facts and circumstances that the indemnification obligations would be honored in full. I think that's an unreasonable position that I doubt that they actually held at that time. Now, it is certainly possible that the global debtors could have chosen to assume the contract. That was a possible outcome at the time. And as Ms. Strickland mentioned, there are lots of restrictive covenants and provisions that are in these documents that would have applied long-term had the debtors done that. Those restrictive covenants and provisions could have been very helpful to the debtors, and had the debtors assumed the contracts, they would have benefited from those. That was, I'm sure, a thumb on the scale in favor of assumption. But, of course, if they assumed the contract, they would have also had to honor the benefits of the contract from the other two parties. But that's just not how things worked out. I mean, ultimately, after the investigations that the Special Committee and the UCC undertook and after negotiations, it turned out that neither Baker nor Putnam received a release. And presumably that determination was based on a determination that the value of the potential causes of action against those parties outweighed the value to the debtor of the contracts and assuming the contracts. That's a legitimate and very reasonable decision for a debtor and its stakeholders to reach. It's absolutely not a sign of bad faith. Last point, there's a suggestion today and also in the papers that it's somehow unfair that Baker and Putnam had to honor their contracts during the short 5 months of this Chapter 11 case while the global debtors decided whether to assume or reject them. But this is true with every executory contract in bankruptcy. Debtors always have time to decide whether to assume or reject a contract while counterparties have to continue performing. If that goes on too long, Section 365 actually allows the counterparty to move for an order from the court requiring the debtors to make a determination about assumption or rejection, something neither Mr. Baker nor Mr. Putnam pursued here, and for good reason, it's only been 5 months. And if post-petition services are provided to the debtor, there's always the possibility of an admin claim for those services. It's hard to imagine any scenario, though, here where that would be appropriate, particularly given that Mr. Putnam did provide very valuable services, and the global debtors are grateful for his services in helping manage the real estate portfolio and moving forward. But he also, as a consultant, was paid very handsomely for that. He was paid $250,000 a month and $1.8 million pre-petition for those services. I think it is hard to imagine how that could not be a reasonable value for the services Mr. Putnam provided, as valuable as they were for the debtors. So in conclusion, I think we should start where we began. It just can't be the case that the law requires the reorganized debtors to pay pre-petition indemnity claims for non-release parties at 100 cents on the dollar. That would be extraordinary. It would be unusual. It would be circular and self-defeating and inconsistent with the bankruptcy code's fresh start and the treatment of pre-petition claims. Your Honor, I'm happy to answer any questions you may have. Otherwise, I'll cede the podium.
All right. No, thank you. Ms. Strickland or Mr. Ghilardi?
Thank you, Your Honor. Can you hear me?
I can.
Great. For the record, Rachel Strickland, Ropes and Gray, on behalf of Mr. Putnam and Mr. Baker. So I want to go back to just the facts as they unspooled here. The clients that I have are sitting in the boardroom. They've been sitting in the boardroom working with the same counsel that's presenting them with agreements across the table. These are employment arrangements. I'm sure they had employment counsel. And what the agreements provide after they vote to resolve to file these petitions and they're actively involved in these cases is something that overtly writes right on the document at the close of business on the 13th. There's no reason for that language to be there unless the sequencing is important. I would say that there was a little bit of a tone in Mr. DiPompeo's argument about the reason these guys are different is because they're bad guys. They're not getting releases, and everybody else, I think he said, was critical in providing ongoing services. Well, they didn't pay Mr. Putnam lots of money out of the goodness of their heart. They did it because he was critical in providing ongoing services. And in fact, they are seeking critical ongoing services from him still. The provisions in the consulting agreements, both of them, arise with respect to indemnification about preservation. They are not providing indemnification that was not provided for under the organizational documents. So terminating the consulting services, which is where the provision that Mr. DiPompeo noted in the consulting period paragraph on page 2 that says we won't have to provide you anything after we terminate the consulting services, does not get rid of things that don't arise under this agreement, but instead arise under the corporate documents of the company. And when you look at in Mr. Putnam's agreement on page 6, where it provides the director and officer indemnification provision, it provides that the company is agreeing and reaffirming that the company group members, not the signatory, wherever they filed, whether it was 1 hour before or 1 hour after, a technicality I would submit is bad faith to submit now and doesn't matter, will indemnify you and hold you harmless to the fullest extent permitted by law and the applicable group members' bylaws or other organizational documents. And it also provides a carve-out that says, notwithstanding anything herein to the contrary, the company group is not required to indemnify you for losses resulting from an act or omission that constitutes fraud, willful misconduct, gross negligence, or any breach of your employment agreement or this agreement. So neither of my clients are saying if, in fact, somebody demonstrates downstream that they did something, which, again, even the termination notice that we received last week provides that it's not for cause. But even if later on, this isn't a circular situation where the trust demonstrates something in bad faith or willful misconduct and they're asking for indemnification, that's expressly carved out. And if you look at the mandatory portions of DGCL, what they cover is actually indemnification after an officer or director has demonstrated that the claims against them are not the case. That, under the mandatory provisions of DGCL, are where they're entitled to indemnification. So we have the sequencing of my guys are on the board, they're being consulted by counsel to the debtors about this whole process. They enter into agreements that provide for what's going to happen over the course of the next 24 months in some instances, 12 months in other instances, and they've got a whole deal. And really, the company has to pay them money, pays Mr. Putnam money for consultation services, also pays for all of his expenses and cooperation. I don't think Mr. DiPompeo disputed that pending, even under their version, assumption or rejection, those obligations are required to be paid by the estates. But then there's an ongoing obligation that under the org documents, not under this agreement, they are going to reaffirm and provide for them, and explicitly in Mr. Baker's agreement, that those are not released. And they get stuff for it. And so what I would say is they can't have it both ways. They talk about estate resources and how everybody would have to weigh in. Then they talk about how much money they've been paying Mr. Putnam throughout all of these cases. Plenty of estate resources. Why? Because he's worth it. Because he has been the linchpin in hundreds of millions of dollars for value for these cases. So I don't think the bad guy overlay argument works, A, because they're not bad guys. And if you look at those consulting agreements, which were done at the moment of, before they filed, those were negotiated, there are statements by Sachs and the global debtors acknowledging the appreciation and the good works that they have and will continue to do. So I think there's been a lot of sort of blurring of the lines here. And as a court of equity, I think we have to look at the fundamental facts. If the sequencing is, I know I'm going to be approving a bankruptcy filing for 30-plus entities, not one entity that's a signatory on this agreement, but 30-plus that have agreed to indemnify me under their org documents where I sit on the board, and in many instances where I'm continuing to provide critical value, and I've got a whole agreement governing the relationship post-filing, which everybody knows is going to happen, to say, oh, well, we didn't really mean it. We meant just until we reject your agreement. So in the first instance, I would say this is a post-petition agreement, and I don't think they can hide behind we didn't follow the law. That's a them issue, not an us issue. But on the flip side of it, even if it is a pre-petition agreement, I do think that it was helpful to get clarification today that they're intending to acknowledge the claims that our clients have against every single one of these entities. And I don't think the circularity arguments regarding the trust hold water in light of what the indemnification actually provides for. So we object to this narrow provision in 6.4 in the plan. There's nothing preventing these debtors from confirming, but to the extent there are valid claims warranting indemnification, not bad guy acts, because those are all carved out, our clients are entitled to that indemnification, and we think that should be reflected in the plan, Your Honor, unless you have questions for me.
No, thanks. Mr. Ghilardi, and then I'll go to you, Mr. Hopkins.
Yes, Your Honor. Thank you. One, reiterating Ms. Strickland's comments, but two, I think if you look carefully at 6.4, it actually says the existing bylaws, corporate governance documents are reinstated. Whether that's assumed, rejected, whether they're contracts or not, it is the existing agreements, the existing organizational documents that are assumed. That's the first thing. Second is taking the opposite side of Ms. Strickland, or in response, let's assume they were all pre-petition claims, us and the other directors. Then the fact of the matter is those are unsecured pre-petition claims. You have to classify pre-petition claims into classes. They did not separately classify them. They are treating them differently. They give a reason, but that reason fails in our mind under 503C. So, one, we do believe we have administrative claims for all the reasons Ms. Strickland said, and two, we think the plan failed because of the failure to classify all of the pre-petition unsecured claims of other directors and officers, and then give the treatment, as I said, like you would a critical vendor, justify that treatment and satisfy 503C, which we don't think they do, Your Honor. And I will just cite two cases. Your Honor is too familiar with CERTA, the CERTA indemnification claims are valuable, and there is a distinction between the way our claims are being treated and their claims. And then I would cite to a transcript of Judge Wiles where in Mercon he actually denied a confirmation where they gave insiders in that case a release, but an indemnity is very similar. You're indemnifying for any claims pre-petition or otherwise. And so the facts there, he said, they didn't put on the evidence to show they satisfied 503C to give insiders this benefit. So we would stand on that and our objection to the plan.
All right, Mr. Hopkins.
Thank you, Your Honor. Chris Hopkins with Paul Weiss of the ad hoc group of DIP lenders and bondholders. I'll be brief. We obviously echo many of the debtors' arguments, but there's just a few points I want to make for the court. On Mr. Ghilardi's 1123A4 argument, I mean, we would reiterate that this provision of the plan is intended to ensure that the directors, officers, and employees who are going to be part of the effort to make this business a success on a go-forward basis are protected and can focus on running that business for the benefit of the brand, our clients, thousands of other general unsecured creditors that rely on this company on a go-forward basis. I reject the premise that that is treatment on account of pre-petition claims these individuals may have. Second, I didn't hear anyone talk about the discharge of 1141D of the code. And so to the extent that Ms. Strickland or Mr. Ghilardi are arguing that DGCL overrides 1141D of the bankruptcy code with respect to pre-petition indemnification rights, whether they arise under a contract or the organizational documents, I haven't seen or heard any authority for that proposition, and I think it's a novel argument, to say the least. And then finally, as Mr. DiPompeo said, I think the DGCL, to the extent it applies, is exceptionally clear that with respect to indemnification or other rights arising under organizational documents, this court's order trumps. It's not really a question about preemption. The statutory scheme under the DGCL expressly authorizes this court, through an order, to modify bylaws of the debtor. Full stop. And I haven't heard any rebuttal or engagement with the effect of DGCL 303 on the arguments that they're making. And then finally, to the extent the argument Ms. Strickland is making is that these are post-petition obligations and that if the debtors violated the law, that's on them, I would beg to differ, because provisions like 503C and provisions like 549, which allow the court to invalidate improper post-petition transfers, exist to protect creditors and other stakeholders of the estate. So whatever the debtors may have done, the purpose of notice and court approval is to protect the estate and to protect my clients, Mr. Marinuzzi's clients, and the people he represents. That cannot be done under cover of darkness. And the notion that our clients, who obviously are supportive of confirmation and supportive of the reorganized debtors emerging a strong, healthy, go-forward company, would sign up and support a plan where their DIP is impaired, they're funding $500 million of new money, and they are allowing a trust to be established, the purpose of which, in part, is to pursue potential claims against Mr. Metrick, Mr. Baker, and Mr. Putnam. And then those individuals would have 100-cent claims against the reorganized business is absurd. And so, unless Your Honor has questions for me, those are the only points I wanted to make. But we support the debtors and believe these objections should be overruled.
All right. Mr. DiPompeo, do you have something else?
I believe Mr. Marinuzzi may wish to be.
Go ahead, Mr. Marinuzzi. Go ahead.
Thank you, Commissioner. It's pretty obvious that we agree with the ad hoc group of lenders and petitioners. There's a reason that the for corporate officers should be approved by a court order. We don't believe any of the arguments make any sense. We can't imagine a world where we're indemnifying the targets of a litigation brought by a litigation trust after the level of negotiations we went through to create the list of excluded parties. And Mr. Putnam provided services. He was handsomely compensated for those services, so it's not as if he did this voluntarily for free. Unless the court has any questions, we just think the debtors are on the right side of this argument as a matter of law and fact.
All right. Thank you. Mr. DiPompeo?
Your Honor, there's obviously a lot more we could say, but I think in the interest of time, I won't unless Your Honor has questions. I'm happy to answer them. Otherwise, we'll rest.
It's 11:18. Why don't we come back at 11:30, and then I'll issue my ruling.